Hello, I'd like to welcome you today on behalf of mortgage compliance investigators to part one of the MVP package. The MVP package is the most valuable package, and it consists of three parts. Part one is the investigation and analysis, which is laying the foundation and accumulating the information for a declaratory judgment. Part two of the MVP package is a state-specific educational sample of a document for a declaratory judgment for suit to quiet clouded title and the rescission of an assignment of mortgage or deed of trust that was ineligible to be recorded. And part three of the MVP package is the online training that ties everything together. Upon completion of part three of the MVP package, the client should walk away with an understanding of the elements relating to a true sale contract pertaining to real property. That being said, let's get started. First and foremost, our legal disclaimer. Legal educational information is not the same as legal advice. The application of law varies within individual specific circumstances. We recommend you consult a lawyer if you want professional assurance that this educational information and your interpretation of it is appropriate to your particular situation. Joseph Esquivel does not offer legal advice and is not licensed to do so. I am not an attorney. Should you so desire an attorney, there are thousands of them that will be willing to take your money in a heartbeat. I encourage everyone to subscribe to Joe Esquivel's Neighborhood, which is the email that Mortgage Compliance Investigators puts out as well. Today we are talking about part one, the investigation. This investigation and analysis is done by a licensed private investigator who investigates the purported true sale of mortgage loan contracts along with the entire mortgage loan instrument, which consists of the following documents: the tangible promissory note, tangible security instrument being either a mortgage or a deed of trust or a security deed, along with the intangible items being the intangible payment obligation. Up on your screen, we also have the link to the website for Texas State DPS should you have any more information relating to the licensing of mortgage compliance investigators. We're going to look at this investigation in layers as one would peel an onion to get to the core of all of the information. So we're going to peel it back a layer at a time. Layer one consists of elements of a mortgage and how they are governed. So we're going to be talking about chattel paper documents and intangible documents. The tangible promissory note. The promissory note, tangible, is a writing in tangible form signed, unconditional, and identifying an indebtedness or unsecured promise by one party, the maker or promisor, to another, the drawer, the payee or promisee, or tangible obligee, that commits the maker, debtor, or tangible obligor to pay a specified sum upon demand or on a fixed or on a determinable date. If the paper promissory note is to be a secured indebtedness, the security instrument is also identified within the paper promissory note. The paper promissory note is governed by Uniform Commercial Code Article 3 or your state's equivalent thereof. A signature on the paper promissory note is not governed by the E-Sign Act, 15 U.S.C. 7003, which clearly excludes items governed by Uniform Commercial Code Article 3 or the state's equivalent. And as such indebtedness can only be in paper tangible form. In simple layman's terms, in order to negotiate the promissory note, it must be done in the paper tangible form. It cannot be done using an electronic copy or transferable record. The promissory note tangible is governed by Uniform Commercial Code Article 3 or the state's equivalent thereof pertaining to negotiable instruments. Let's take a look at the tangible security instrument. This tangible security instrument would be either a mortgage, a deed of trust, or a security deed if you were in the state of Georgia. Okay, so let's look at security instrument tangible. A writing in tangible form to memorialize obligors or debtors' pledging of an asset or property as an alternate method to secure payment to a tangible obligation if in accordance with all applicable laws of local jurisdiction, governed by local laws of jurisdiction which the real property resides. In layman's terms, the security instrument is an alternative means of collection of the debt when followed with all applicable laws. If in accordance with all laws of local jurisdiction. Simple to understand. All right, let's talk about the security interest. The pledging of the tangible, alternate, real property rights for payment. The pledging of tangible, alternate, real property rights for payment. So we're talking about the security interest of the security instrument. Many times when you're looking at an assignment of mortgage or assignment of deed of trust, it says transferring the beneficial interest. This is that interest. C, security interest. An interest constituting a lien or claim created by a security agreement, mortgage, or deed of trust, or by the operation of law that, if valid and enforceable, provides the alternate means to fulfill value of an intangible financial obligation between the tangible obligee and the tangible obligor. Thus, if such security interest, mortgage, or deed of trust is no longer valid or enforceable in accordance to local laws of jurisdiction, then the tangible UCC note is no longer secured by such security interest. In a nutshell, if by operation of law the security interest is no longer valid or enforceable, then the UCC tangible promissory note is no longer secured by the security interest. This security interest is governed under Uniform Commercial Code or your state's equivalents thereof pertaining to secure transactions. Article 9 applies to personal property, not real property. Let's talk about the promissory note. Intangible, E-note. E-note stands for electronic note. Created electronically, stored electronically, transferred electronically. Intangible payment obligation. D, promissory note. Intangible E-note. Intangible payment obligation. An electronic transferable record created during securitization. Okay, we're going to stop there. Created during securitization. When the documents are sent back to the original lender after closing. They're scanned in within the first 24 to 48 hours into a digitized format. Once they're scanned in, a transferable record is created. It is this transferable record that becomes the electronic e-note. And it's signed in accordance with the e-sign Act that commits the maker, all right, the maker is a third party, and they're called the account debtor or the intangible obligor. All right, now you're going to find that definition under UCC 9-102 or your state's equivalent thereof. Under the definitions, it says, account debtor means a person obligated on an account, chattel paper, or general intangible. The term does not include persons obligated to pay on a negotiable instrument. So you have a third party creating an intangible obligation using the payment stream from the tangible promissory note. So now we have two intangible obligations. Okay, now, transferable records are governed by UCC Article 8. And the security interests securing transferable records are governed by UCC Article 9. We just talked about those. So when we talk about the intangible, the e-note, transferable records, they're governed on Uniform Commercial Code Article 8 under investment securities. We talk about the security interest, the intangible to UCC Article 8, the e-note. Okay, E, security interest, the intangible to the UCC Article 8 e-note. Intangible obligations created during securitization by an account debtor are routinely swapped for another intangible obligation, certificates. So let's pause there for a second. Many times, if you take the time to read a pool and servicing agreement or a 424B5 prospectus or a prospectus supplement, you'll notice many times it is stated within those governing documents, it'll say a sponsor, seller, will own no assets. Depositor will own no assets. And yet if you ask yourself, how the heck are they purchasing these items? The reason they cannot own any assets is that they are to be bankruptcy remote. So if something were to happen, they could not be sued and their assets could not be taken. So they use what's routinely called swap certificates. You know, I'll swap this for you. In return, you give me what you have. Okay, so let's continue. And as being a transferable record, such transaction would fall under the governance of UCC 8. Transferable record falls under UCC 8. For the certificate intangible to be secured by an intangible account debtor's personal property, the negotiation of the intangible obligation must be in compliance with UCC 8 as it applies to transferable records. As to the personal property securing the transferable record, UCC 9 would provide governing law. UCC 9 goes to personal property, UCC 8 goes to transferable records, securities. Okay, let's go on to layer 2, land records. What are land records? Land records are documents of transactions being claimed that have been recorded into public record, thus giving constructive notice to the world. Okay, so this would be at either the county recorder's office, at the county registrar's office, and there could be any number of filings. It could be You could have mortgages filed. You could have deeds of trust filed, assignment of mortgage, notice of default, substitution of trustee. So what you have to understand is what is it that these transactions are doing. So when you look into the land record, when something is filed at the county recorder's office, it is filed, indexed, and recorded, thus giving constructive notice to the world. Let's take a look at an assignment of mortgage. What is the purpose of an assignment of mortgage? Well, the purpose of an assignment of mortgage is to memorialize the sale of the tangible promissory note as well as the acquiring of rights. However, the assignment of mortgage does not cause the sale. The sale is caused by negotiation, transfer, and delivery pursuant to UCC 7-501 or your state's equivalent. So when we look at the land records, we're looking at what is being claimed. This is where hearsay claims to color of title come in. All right, so that's layer 2. Let's go to layer 3, statutes and law. We have all sorts of statutes. So where do we look? Well, we have United States Code, we have federal law, we have Uniform Commercial Code, we have state laws, we have local law of jurisdiction. All of these statutes all take place all at the same time, all within the different documents and the different transactions pursuant to this true sale. So it is having an understanding of all of these statutes and as they apply to the transactions in which an analysis of the investigation is able to be made. One of the things after looking at public record is what should have happened. Well, in looking at the documents, one of the things is that the sales need to be a minimum 2 transactions out in order to qualify for being a RMIC. So the purpose of a RMIC for an RMBS trust, residential mortgage-backed security, or a RMIC real estate mortgage investment conduit, is that it is a pass-through entity. So in order to avoid double taxation, there were certain timing requirements that had to be done, certain transactions that had to take place. So you're talking a minimum of 2 additional true sales before reaching the final party. So the first sale would go, say, from party A to party B, and along with the sale of the tangible negotiable instrument, we would have the first assignment with party A releasing its security interest in the security instrument, being either a mortgage or a deed of trust or a security deed, and then assigning this interest to party B and recording this transaction into public record where it would be filed, indexed, and recorded, thus encumbering this lien and having a properly perfected instrument, a true sale of the mortgage loan instrument, properly secured sale. So we could have from the original lender to the originator, the originator to the sponsor seller. Right? So second sale would go from party B to party C of the tangible promissory note. It would be done through negotiation, transfer, and delivery, along with an assignment from party B releasing its security interest in the security instrument, and then assigning that interest to party C and recording this transaction into public record. There was a third sale from party C to party D. It would go along with an assignment, with Party C releasing its security interest in the security instrument and then assigning that interest to Party D and recording this transaction to public record. There was a fourth sale, then it would be from Party D to Party E, say from the depositor to the trustee, or from the trustee to the certificate holders. Along with an assignment to Party D releasing its security interest in the security instrument and assigning the interest to Party E and recording this transaction into public record. Again, depending on the nature of your particular situation, you would have anywhere from 3 to 4. A minimum of 2 arm's length transactions. You would not go from Party A to Party E. Should you go from Party A to Party E, you did not have true sales. They were not bankruptcy remote. They were unenforceable pursuant to the governing documents. This is something very important to look at, pay attention to. Layer 4, comparison. Comparing all documents and records of both tangible and intangible to the statutory requirements of law pertaining to the sale of the entire mortgage loan instrument, consisting of the tangible promissory note, a tangible security instrument securing the indebtedness, and the intangible obligation, which is a promise to pay. So layer 4 is where we're actually comparing all of these items. So I've got stacks of papers, I've got monitors with just document after document. So the documents are actual documents I'm looking at. I'm looking at statutes pertaining to law. I'm looking at 424B5 prospectus. I'm looking at a pool and servicing agreement. I'm looking at a Freddie Mac custodial procedure handbook. And then I have to disseminate all that information. So some of the documents that I'm going through at the same time, I'm going through the free writing prospectus, the trust agreement. I'm going through selling guides. I'm going through custodian manuals. I'm going through custodial agreements for Fannie Mae, Freddie Mac document custody procedures handbook, and many, many, many others. Depending on your situation will depend on what documents I will go through. What did happen? As well as what did not happen or not take place according to the statutory requirements of law, as well as the governing documents that were required in order for true sales to take place. Because there are certain transactions that are set forth in certain documents that govern these trusts, we look at what did not happen. What requirements were violated in regards to keeping tax status as a REMIC? Were the timing requirements met? Yes or no? Because pursuant to being a REMIC, there are certain IRS tax requirements that must have been met in order for this trust to keep this status. One of those items was a timing requirement in which all the assets of the trust are required to be within the trust within the first 3 months of startup. Kind of funny, because when you see some of these assignments of mortgage, assignment of deed to trust, they're done 5, 6, 7, 8 years later. So I'm looking at what requirements were violated, what laws were violated, what governing documents did they not pay attention to, what IRS codes should have they been following. All of this information brings us to a conclusion, and we put these findings into a concise package that consists of your investigation and your chain of title analysis package. Okay. This is what your package cover letter looks like, or your package cover page looks like. When you get this, take the time and go through it. Go through page 2. Page 2 is a boilerplate layout of the basic content as to how the investigation was done. The elements of a mortgage loan instrument, we've talked about these. What should have happened? What did happen? All this information is very, very important. So I ask that you go through it. Section 2, unique mortgage loan details. So depending upon your situation will depend upon what loan transaction information we have. Section 3, we get into the MCI infographics and the mortgage fraud investigation, as well as the actual chain of title analysis. Section 4, we get into applicable educational material. If there's New York trust law or Delaware trust law, we provide it, as well as giving information on endorsement and types of endorsement. This is very, very important information. So as we're going through it, again, we've gone through the elements of a mortgage loan instrument and how they're governed. So I would ask you to take the time to read this, understand it. Understanding what you are looking at and what we've already gone through makes a better educated client. When we actually start going, when you get to the analysis and you start going through the infographics, all right, the infographics are specific to your situation at hand. Mortgage compliance investigators created these infographics from scratch. To date, we have about 30 of them. They're all different. For these infographics, they show different items that happened or did not happen as described in the analysis. For this particular one, this was an RMBS trust. When you look at the infographics, it's divided into two halves, left half and the right half. The blue boxes identify the parties to the transactions. The green boxes denote the tangible promissory note as well as the intangible payment obligation. The gray boxes denote the security instrument, being the Doe mortgage. The brown boxes represent the county recorder's office. So if we were to start from the beginning, we would see that the borrower was Jane Doe. I'm looking at the left-hand side. Jane Doe signed at closing July 6, 2005. Okay, shortly after they signed, the Doe mortgage was signed, recorded, filed, indexed at county recorder's office. It was sent back. When it was sent back, it was a properly perfected lien with the Doe note. Okay. The originator then sold the note, intangible payment obligation, to the sponsor seller. At the same time, did an assignment of the Doe mortgage and filed index and recorder at the Orange County Recorder's Office. After which it was sent back, it was properly perfected, and when the sponsor seller got the properly secured promissory note along with the properly secured DOE mortgage. The sponsor seller then sold that instrument to the depositor. The depositor then received the DOE tangible note with the intact intangible payment obligation, and the sponsor seller did an assignment to the depositor, recorded this assignment, index filed at county recorder's office. The depositor then sold the note, being payment and the payment intangible, to the trustee, which was Deutsche Bank National Trust Company, and at the same time they sold to the trustee, there was an assignment assigning, releasing the beneficial interest and assigning the new beneficial interest to the trustee, Deutsche Bank, where it was filed, recorded, indexed at Orange County Recorder's Office. The trustee then took this tangible promissory note that was properly secured through an encumbrance filing at the county recorder's office, and then sold this tangible promissory note, at the same time selling the note to the RMBS Trust 2005-4. It did an assignment that it filed with county recorder's office, where it was filed, indexed, and recorded. And all of this took place by August 17th of 2005. Now, they closed July 6th of 2005. Normally, this would take about 150 to 180 days to take place if you had done this prior to the formation of the mortgage electronic registration systems called MERS. Now, when we look at what happened on the right-hand side, the parties are the same. However, the transactions don't look the same. Okay, so we're going to start at the top. Well, there's a closing date. We have the DOE note, the DOE mortgage. Security instrument is recorded at Orange County Recorder's Office and back to the originator is properly perfected. All right, so now we've got a properly secured note and intangible obligation secured by a security instrument being the mortgage. Within the first 24 to 48 hours, the paper note is then scanned into the system where it's digitized, all right, and becomes a transferable record. The tangible is stamped with a payee on named, and then the tangibles are often vaulted or they're destroyed. They're shredded many, many times. They just become instantly invisible. They're gone. Nobody knows what happens. However, when that happens and the documents are scanned into a digitized format, thus a transferable record is created. This transferable record being the E-note. Now, this intangible payment obligation is stripped and transferred electronically. All right? So now when that obligation is being stripped out and transferred, the DOE tangible promissory note is no longer the entire instrument. It's less than full value. And nothing was recorded showing this transaction at county record. So when that payment intangible obligation has been ripped out from the DOE note, it no longer has any debt to evidence. With no debt to evidence, the mortgage expires by operation of law because it decreased in value. The value was the promise to pay future payments. When that was sold, by operation of law, the security instrument became a nullity. Now, the originator sold to the sponsor seller. The sponsor seller then took that intangible payment obligation, being a transferable record, And that transferable record under UCC 8 was then sold to the depositor, who then took that intangible payment obligation and sold it to the trustee. And as that intangible payment obligation of the trustee sold to the trust. However, this was all done electronically. Years later, upon when there was a presumed deficiency of the payments to the payment stream, evidenced by the tangible promissory note, years later they were assignments. However, these assignments, while they were to memorialize transactions of the tangible promissory note, they were not evidenced by the tangible promissory note, nor were they timely pursuant to 9312. Again, we talk about the assignments memorializing a sale, not causing a sale. And while there is a temporary perfection afforded the sale of a negotiable instrument, if one were to look, and let's use California for example, under 9312 of the Uniform Commercial Code, or in this case the California Commercial Code, it's under perfection of security, interest, and chattel paper, deposit accounts, documents, good covered by documents, instruments, investment property, letters of credit, rights, money, and insurance. Perfection by permissive filing, temporary perfection without filing or transfer of possession. Okay, so when we look at this, A is going to tell us a security, interest, in chattel paper, negotiable documents, instruments, or investment property may be perfected by filing. Okay, now we're just going to cut down to the chase, and we're going to look from E through H. E, a security interest in certificate securities, negotiable documents, or instruments is perfected without filing or the taking of possession or control for a period of 20 days from the time it attaches to the extent that it arises for new value giving under an authenticated security agreement. Okay. F, a perfected security interest in a negotiable document or goods in the possession of a bailee other than one who has issued a negotiable document for the goods remains perfected for 20 days without filing. All right, let's jump down to H. You can read this a little later on. You can review it. We've got a lot more information to cover. H, after the 20-day period specified in section E, F, or G expires, perfection depends upon compliance with this division. So in a nutshell, layman's terms, if after 20 days perfection of the tangible has not taken place, and perfection would be where one would file an assignment of deed of trust, an assignment of mortgage, assignment of security deed into public record, giving constructive notice to the world, all right, then by operation of law, Humpty Dumpty falls off the wall and cannot be put back together again. So not only must the transactions with the chain of documents match the chain of title recorded into public record, it must also be timely. It must be timely. You cannot do it 5 years later and say, well, you know what, we're going to memorialize that transaction that we did 5 years ago. Can't happen. All right, so that being said, let's continue. Information on endorsements, real brief. The endorsements, we're going to go over the endorsements are at the end of the analysis. So the endorsements I've gone through and I've done samples. I've done blank endorsement, special endorsement, restrictive endorsement. We've actually gone through and put the definitions of the endorsements pursuant to the Uniform Commercial Code. Now, while your state has its own specific laws and statutes regarding endorsement, regarding special endorsement, blank endorsement, this pertains to the Uniform Commercial Code. Your state's equivalents will be very close or exactly the same. So let's just real quick look at 3204. 3204 says endorsement. Endorsement means a signature, other than that of a signer as maker, drawer, or acceptor, that alone or accompanied by other words is made on an instrument for the purpose of negotiating the instrument. 2, restricting payment of the instrument. Or 3, incurring endorser's liability on the instrument, but regardless of the intent of the signer, a signature and its accompanying words is an endorsement unless the accompanying words, terms of the instrument, place of signature, or other circumstances unambiguously indicate that the signature was made for a purpose other than an endorsement. For the purpose of determining whether a signature is made on an instrument, a paper affixed to the instrument is part of the instrument. So at the last sentence, they're talking about in launch, must be permanently affixed, not a separate piece of paper held together by a paper clip. Now, an endorsement consists of a signature. Many times you will hear the bank or a servicer or a third party claiming we have the original note. We have it with a blank endorsement. It is bearer paper. All right, 1, it's not bearer paper. 2, the instrument that they're holding says paid to the order of with an as of yet unnamed payee. Now, an as of yet unnamed payee, paid to the order of with an empty space. Okay, when we look at special endorsement and blank endorsement, under 3205, if we look at A, it says if an endorsement is made by the holder of an instrument, whether payable to an identified person or payable to bearer, and the endorsement identifies a person to whom it makes the instrument payable, it is a special endorsement. When specially endorsed, an instrument becomes payable to the identified person and may be negotiated only by the endorsement of that person. The principle stated in 3-110 applies to special endorsements. So, special endorsement means a special, specifically identified person. Pay to the order of, or pay to bearer. B-E-A-R-E-R. I have yet to see a note endorsed pay to bearer. B-E-A-R-E-R. Okay, let's look at B. Because B is many times what the banks say, well, if an endorsement is made by the holder of an instrument and it is not a special endorsement, it's a blank endorsement. When endorsed in blank, an instrument becomes payable to bearer, B-E-A-R-E-R, and may be negotiated by transfer of possession until specially endorsed. True. If an endorsement is made, what is an endorsement? An endorsement is a signature. All right. So we need to have a signature. And it says it is not a special endorsement. So that means it cannot have the words paid to the order of, but that specifically identifies. It gives intent. What is the intent? All right, so let's look at C. The holder may convert a blank endorsement that consists only of a signature. into a special endorsement by writing above the signature words identifying the person to whom the instrument is payable. Pay to the order of. If we put that above the payee name, it is now going from a blank endorsement to a special endorsement. Until the payee is named, negotiation cannot take place. So this empty space must be filled. If we were to take a look, I'm going to use California. California Commercial Code 3203. Okay, let's look down to 3203. Transfer of instrument, rights acquired by transfer. C, unless otherwise agreed. If an instrument is transferred for value and the transferee does not become a holder because of lack of endorsement, because of lack of, let's put the word signature, by the transferor, the transferee has a specially enforceable right to the unqualified endorsement of the transferor, but negotiation of the instrument does not occur until the endorsement is made. So if the endorsement is not made, negotiation does not occur. All right, at that time, that document would fall under 3115 under incomplete instrument. Now let's just take a look down at 3203D. All right, because, for instance, they've done an assignment of mortgage, all right, if they've done an assignment of mortgage and on the note there is no named or identified payee, then they've only transferred the mortgage. They've assigned the mortgage. Fine. They did not assign conditions over which rights to enforcement have been transferred. Rights to enforcement, okay, rights acquired by transfer will again go to 3203. If a transfer purports to transfer less than the entire instrument, negotiation of the instrument does not occur. The transferee obtains no rights under this division and has only the rights of a partial assignee. So the laws are there, people. We need to follow the laws. They need to follow the laws. All right. So along with your package, you're also going to receive any trust agreements, pool and servicing agreements, prospectus supplements, circular supplements, any documentation that I would come across in which I would review in order to complete my investigation, you will receive a copy of as well. As well as a voluntary liens report if I'm able to pull one. This will show you all of the recorded documents, all of the transactions that have been listed at the county recorder's office or at the county registrar's office for your specific county or parish, depending where you're at. You will also receive an affidavit of fact. The affidavit of fact is strictly that. It is an affidavit of Joseph R. Esquivel, Jr. In the earlier, we've gone through the documents that I had looking at. These documents, I then state, what did I see? What did I look at? I looked at a deed of trust dated July 6th. I looked at a true and correct copy of a note dated July 6th. Again, so whatever I am looking at, I tell you what I look at, what did I see? This copy of the Jane Doe note shows no endorsement to any named party. Okay? The multiple classes of the New Century Home Equity Loan Trust 2005-4 are not named in any way on the John Doe note. Carrington Mortgage Services, LLC is not named or referenced in any way on the John Doe note. So any document I look at, I am given an actual statement as to what I have seen. I have looked at the Greene County record relating to the Jane Doe deed of trust dated July 5th. The Greene County record shows a substitution of trustee where Deutsche Bank National Trust Company is indentured trustee for New Century Home Loan Trust and substitutes Atlantic and Foreclosure Services as trustee. So I am strictly stating the facts. The facts back up the analysis. What did I see? What did I review? This can be entered into court as an exhibit, as an affidavit of fact. The analysis is an analysis and an investigation and is an educational piece that can be entered into court record as well as an exhibit, as an educational piece. This is an analysis by a licensed private investigator. It's knowing how to use the information, people. That's what we're here for. Yeah. The whole point of the investigation is for you to be laying the foundation for the information for the declaratory judgment. The declaratory judgment, that is where the information is coming from this investigation. Because what is in county record, because of the documents that have been filed, indexed, and recorded, there is a color of title on your property. There is the appearance of a legally enforceable right of possession or ownership. There is a written state instrument that purports to transfer ownership of property, but due to some defect does not have that effect. A document purporting to pass title to land, such as a deed that is defective due to a lack of title in the grantor, passes only color of title to the grantee. In other words, if there is an assignment of mortgage recorded, indexed, and filed at the county recorder's office that does not have a transaction that matches it on the tangible promissory note, and if this was not done in a timely fashion, then there is only color of title. There was not true title with legal rights conferred. When you understand title is a union of all the elements constituting the legal right to control and dispose of real property. Title is a legal link between a person who owns property and the property itself. Title is a legal evidence of a person's ownership rights or interest in real property. Title is the conditions necessary to acquire a valid claim to real property. This is what we are investigating. This is what the analysis and the investigation will show. Okay, with that being said, I'd like to conclude with our phone number. Should you desire any more information, you may call us at 888-491-3741. Again, the phone number is 888-491-3741. Or you can go onto our website at www.mortgagecomplianceinvestigators.com. I'm looking forward to seeing you in part 2 as well as part 3. So thank you very much for your time, and we'll talk to you soon. Thank you.